Do you think that you're guilty?
I'm sorry?
What did you do that makes you think you're guilty of this offense involving a Toyota?
Taking the car without permission.
Pardon?
Taking the car without permission.
And whose car was it? Do you know? You do not. You just took the car, drove it away, didn't have anybody's permission or authority to take that vehicle. Is that correct?
Correct.
All right. Counsel, have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation court is ordered at 15th District Court probation. Sentencing in this matter will be
At 1:30 before Judge Valvo.
January 9, 2025, 1:30.
Yes.
1:30 before Judge Valvo. Bond will continue.
Your Honor, if I may briefly address.
Of course you want to.
Thank you.
Go ahead.
Your Honor, just so the record is clear, Mr. Simpson is held on another matter, retail fraud out of before Your Honor, that is set for a pretrial on the 18th. Considering that he has entered a plea on this case, I would just ask the court to consider either amending his bond to something lower. The bond on that case is $1,000, $1,000, 10%. If the court would consider setting that bond here in the event that he resolves the retail fraud.
What's his retail fraud bond?
Oh, 1,000, 10%.
Response from the people.
The only thing I would indicate, Your Honor, I don't have a effective request. What I show on Mr. Simpson's criminal history is 2022 assault and battery out of Biscuit, battery out of 14A2, and as well as a 22 assault and battery out of the district court. I don't show any other.
So he's got a 10,000 cash surety on this case. And well, is he going to be able to post either one of those? I mean,
No. Okay.
I mean, I'll give him a 10% privilege on this case, but I don't.
I would ask for that in the event that he resolves the retail fraud. I just come up with the money he may be
I'll
able to.
grant the requested. The bond in this case would be a 10,000, 10% bond. We'll change that bond on this one. Okay,
Understood. Thank you.
thank you.
We'll see Judge Valvo on Monday. Okay.
Court does call the case of the people versus Amanda James.
Assistant Public Defender Chelsea Virgils on behalf of Amanda James. I'm sorry, Your Honor. I have not seen my client today. I did speak with her yesterday and throughout the week, she expressed to me that she has some severe disabilities due to a car accident. So I made a Zoom request yesterday, but I think it may have been too late. I don't know if she appears via Zoom today.
No,
No, okay.
not here.
I apologize, Your Honor. I would ask you to consider adjourning this probable cause conference. We were going to ask to adjourn for discovery.
Bench warrant will issue for defendant's failure to appear, bond sitting at 10,000 cash share. Court calls the case people versus Thomas Rastel.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Rastel.
About time. Warren Green, he was
State your name.
he was sitting there.
Thomas
doing nothing.
Rastel.
Thank you, sir.
Your Honor, today's date and time for probable cause conference. We are requesting an adjournment I provided the court with a stipulation and proposed order. We're asking the court to consider a release to treatment in this matter.
He's screening for the 14A treatment court.
Correct, Your Honor. I do have the referral form. I wanted to review that with my client, and then I would provide that to the court. I discussed it with Ms. Londi. She did sign it on her behalf, so I just need to review it with.
Well, and not until he gets his initial screening, am I gonna have a release on this one. I'll adjourn it out. How long is that process taking?
Your Honor, I can't tell you with certainty. I would imagine it'll be longer than 2 weeks.
And because he's in custody, I don't have an issue adjourning 2 weeks and we can see where we're at. If the court wants to sort of keep an eye on things. I know that the defendant has substance abuse issues. The reason that people are not comfortable agreeing to just a PR at this point is just his criminal history. Unfortunately, we can't ignore that, but don't want him to spend any more time in custody than absolutely necessary.
All right, let's do this. I'll adjourn his probable cause to January 2nd, 2025, 9 a.m. Bond continue. All right, thank you. Court calls case People versus Jermaine John Giles.
That's the one.
Or John Gillis.
But not with Jermaine. John Gillis.
Oh, sorry.
Yes,
He's in MDOC,
that is correct, Your Honor.
but we don't know where.
I think I saw Egler.
Oh, he was just transferred Tuesday.
Tuesday morning.
Okay, then let me do this. I'll grant your adjournment. I'll adjourn this to January 2nd, 2025.
Thank you, Your Honor.
And we'll bond continue. Thank you. I apparently said something. I don't know why Ames mad at me. Just try to be nice. It's hard. Court calls case People versus Benjamin Meyer.
Hey, Mr. Sinatra for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Meyer, who's approaching to my right. Judge, state your name, Mr. Meyer.
Benjamin Meyer.
Your Honor, this is time for a probable cause conference. I have had a chance to discuss this matter with Mr. Meyer in some detail. There is some investigation I would like to do. I'd ask the court for a brief adjournment of the probable cause conference.
How long will it take you for your,
I'd ask for 3 weeks, Judge.
pardon?
I'd ask for 3 weeks.
3 weeks. All right. Probable cause conference, January 2nd, 2025. Told you. Just 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
No. What? I was good until you made me nervous. Take Emily out. Here goes the case People versus Joelle. No, it's Joelle Jones. It's, I don't know. She's here. She can tell us.
Joyelle.
Okay.
Brian Bowling on behalf of Ms. Jones.
Okay. Ma'am, can you state your name, please?
Joyelle Jones.
Okay, I just was not sure where to put the break, so that was
I
my
know.
it could be Joyelle or Joyelle. All right.
I get it a lot.
Okay. All right. You're asking for an adjournment?
I am, that's correct, Judge. Mr. Childers has made an offer, which I have spoken to Ms. Jones. There's one other thing I'd like to try to figure out for Ms. Jones' peace of mind before she moves forward.
Probable cause conference, December 26, 2024, 9 a.m.
Thank you.
Bond will continue.
I'll be in touch, Ms. Jones.
Thank you, Ms. Jones.
Thank you.
Thank
Have a good one.
Court calls the case, People versus Bradley Smith.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Smith. Mr. Smith, will you state your name for the record?
Bradley Smith.
Your Honor, I last week provided all of the documentation.
Pineapple, hold on. I read that.
Police report as well for no contest.
I got the police report.
It's probably not a, my understanding, Mr.
Oh.
Smith is pleading to count. It would be this one too.
That is correct. That is my fault.
It was, oh, yeah. That I'm looking for a form that isn't, it doesn't exist.
Doesn't exist.
You almost got Ann yelled at. Because of your behavior. Need to apologize to her. May I have him sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Bradley Smith.
All right, sir, it is this court's understanding that you're gonna plead guilty to the charge of operating while intoxicated.
No contest, Your Honor.
No contest, excuse me, to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service and any rehabilitative programs the court needs necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes,
All right. Do you understand what a no contest plea is?
I do.
All right, two things about a no contest plea. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing that you need to understand about it is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? But you understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B district.
Okay.
You understand that?
I do.
All right.
Yes, Your Honor.
Basis for the no contest plea.
Your Honor, lack of recollection.
So to that charge, sir, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Yes, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on my form. You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation?
No.
On parole?
No.
Anybody promise you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will?
Sure.
All right. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-83322. Any objection to the court having reviewed that report?
Objection.
No, Your Honor.
Based on the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of this defense counsel. Have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
January 16th at 10 a.m. before Judge Washington.
January 16, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond in this case will continue.
Thank you.
Thank you.
When you, I'm making sure that.
Court calls the case of the People versus Richard Laster.
Ashley Lund for the people.
Public Defender Chelsea Regiels on behalf of Lakira Laster, formerly Richard Laster, who I believe appears via Zoom. Ms. Laster, can you unmute and state your name?
Is it working?
You're unmuted and we can see you. State your name.
R. Laster.
All right.
Your Honor, I submitted a plea form today. My client would like to accept the offer available in this case.
The board have a copy of it?
Nope. I have not, I don't have. Does anybody have it? No, I think Bellinger has it. I'm just saying, I think he's taking things. Nothing, don't worry about it. Don't worry about it. People are accusing you of things. Don't worry, I got you. I'm defending you. I don't have,
You know, maybe Alan put it wrong.
Alan put it in the wrong place.
Alan.
Is that it?
put it-
Ah,
Excellent. Your Honor.
Emily put it in the wrong file. She's trying to blame Alan. It's not Alan's fault. This is the only thing that's not Alan's fault.
Upon review of that plea form, the court will see the offer is to plead to count 2 of use of a controlled substance to wit cocaine and 1-year misdemeanor and or $2,000 fine, contrary to MCL 3337404-A. Upon a plea of guilty to that count, the possession of cocaine and 4-year felony will be dismissed for section 411.
Okay. Got it. That's what the form says. That's the court's full understanding. Is that correct, counsel?
I believe so, yes, Your Honor.
Oh, very good. All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Can you state your name for the record?
R. Lasser.
All right. And just so that our file is correct, formerly known as Richard
Yes, Your Honor.
Keith Lester. Got it. All right. So it's this court's understanding that you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. You understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
Okay. And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. When you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Okay, has anybody threatened you or coerced you in any way?
No, not pertaining to this.
Pardon?
Not pertaining to this, no.
Okay. As it regards this case, you're doing this voluntarily and of your own free will?
Yes.
All right. And also because you believe that you are indeed guilty of this offense?
Yes.
All right. February 2nd, 2024, at the location of Oakdale and Packard in Pittsfield Township, Washtenaw County, state of Michigan. Did you have cocaine in your possession?
Unbeknownst, yes.
All right. And had you used it?
At that time, yes.
I'm sorry?
At that time, yes.
All right. And did you know what you were using was cocaine?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this case will be
At 9 a.m.
January 15, 2025, 9 a.m. That's before me.
January,
Please.
I just want to know if you had a Charles Daniel.
Technically, yes. Thank you for catching that. Just put it on there. They'll waive his
Yes, John,
appearance, I'm
ready.
sure.
We're ready on Powers.
Thank you. Okay. Good morning, sir. How are you today? Good. All right. What's your name? Thank you. All right. Calling case number 240-449-2001, people of the state of Michigan versus Jeremy Earl Powers. Counsel.
Thank you, ma'am. Good morning. I believe this is an attorney general case, so the city isn't going to be appearing.
Thank you.
Jessica Shive on behalf of Mr. Powers, who has formal reading, understands his constituents and stands beyond and is present in the courtroom.
Thank you, counsel. Court notes formal reading has been waived. Enters the not guilty plea on Mr. Powers' behalf. Charge here is disassociated person from the casino trespassing. Positions as to bond.
As to bond, Your Honor, respectfully asking the court to consider a personal bond. I believe this matter is going to be resolved, and this is not assault. If he walked in, he's not at flight risk, Your Honor.
All right, thank you. Correct. I'm not seeing anything, any assault of risk to the community or flight risk here. We'll set bond. We'll set bond at $1,000 personal. Right. Next court date for you, Mr. Powers, is going to be December the 23rd for a pretrial. You'll be in front of Judge Bryant. Okay. Thank you. Have a good day. Can you guys hear me over at DDC? Good morning. Do you guys have any way of, can we get Ms. Gill on screen on the female side? I've got retained counsel for her.
So you want the female first?
Yeah, is that okay? Or if they, let's see. I think that's the only one I have on the female side. So yeah, that would work if it works for you. Great. Okay. Thank you. Oh, we have two? Oh, that was peace sign. Okay. All right.
That's right here. We have Melissa Gill and Monisha Hill, correct? Those two?
Okay, well, I'm at least ready on Gill. Do I? Yeah, I don't have another file. I just have Gill, Gill.
Copy that.
Thank you. Why are these undelivered? What is happening? Oh. Madam Clerk, there were 2 denials that I sent back this morning, but I'm getting an undeliverable. Can I give you the names of those defendants, just so? My emails marking them no probable cause found did not go through. And I just want to make sure they know in the back that they've been denied. I don't know why they're not going through.
Okay, okay, you okay.
Yeah, the first name is Samuel Colson, Colson, first name Samuel. No probable cause found. The other one is going to be Anthony Baxter. Okay, no probable cause found. Thank you. I sent them to the back, but for some reason they're bouncing back to me.
Okay, I'll make sure that they know.
Thank you. Thank you. All right, ma'am, what's your name, please? Good morning.
Good morning, Melissa Gill.
Okay, Ms. Gill, you've got some traffic misdemeanors where you missed court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'll set those warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. They are misdemeanors, which the maximum possible penalty is up to 93 days in jail and or a $500 fine. First ticket is P1104339. Alleging August 9th of 2020 in the area of Faust and Joy, that your driver's license was expired. Then P1230786 alleging August 1st of 2021 at Mac and Bothay, that you had open alcohol in the vehicle as the passenger. P1246824 alleging September 7th of 2021 at Schoolcraft and Fielding, license suspended, no insurance. P1255276 alleging January 26, 2022 at Linden and Stansbury, driving while license suspended, no registration, no insurance. P1263068 November 2nd of 2021 at Chalmers in Houston, unregistered vehicle, no insurance, license suspended. P1311320 March 24th of 2022 at Livermore in Ewald Circle, unregistered vehicle, no insurance, no license. P1499472 September 12th of 2023 at Fitzpatrick and the Southfield Cutoff, license suspended, no insurance. P1507818 October 5th of 2023 at Burt and Capital, license expired, no insurance. X4229382 May 30th of 2023 at 96 in Wyoming, license suspended, no insurance. Then we've got P1507799 October 5th, 2023, Burt and Capital. These are all civil infractions, no misdemeanors on that ticket. P158. Yeah, these are all, one moment, please. These are all civil infractions. And one ticket that's all civil infractions. I'm not sure why this one is before me today. Hold on. Yep. All right. P1587272 May 25th of 2024 at Avon and 7 Mile, driving while license suspended. And then X4229382. This one, license suspended, revoked, or denied. No insurance on that one. All right, on all of these, you do have personal bonds. Your next court date is going to be January 16th, 2025 in front of Judge Perkins. There's that ticket, Madam Clerk, and I'll just ask you to look for the mitt once I'm done signing.
Okay.
So I don't have to stop to do that. Now calling case number 240-583-7601, People of the State of Michigan versus Melissa Gill. Counsel.
Good morning,
Thank you.
Eric. Eric goes on behalf of Ms. Gill.
And Steve Vincent for the people, please 71917.
I apologize, Mr. Benson.
No problem.
That's
okay.
No problem. No problem.
Judge, for purposes of the arraignment on the warrant, we will waive the formal reading of these charges and stand mute at this time.
All right, thank you. Court notes formal reading has been waived and is not guilty plea on your client's behalf. Madam Clerk. All right, thank you. All right. Court notes formal reading has been waived, interest and not guilty plea on your client's behalf, and we will begin with arguments as to bond from the people.
Thank you, Magistrate. Had the opportunity to read the allegations. Kind of a crazy fact pattern here. Fortunately, nobody was hurt. At this time, we're not going to be objecting to a personal bond.
And I would
Thank
also request the same, Your Honor.
All right, thank you. All right, charge here is CCW. We'll set bond at $5,000 personal. Ms. Gill, you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Your next court date is going to be a probable cause conference in front of Judge Robbins on December the 20th. After that, a preliminary examination is scheduled for December the 27th.
Perfect.
All right.
Thank you much.
you.
We're all set.
Thank you. All right.
Ms. Gill, you got a
We're
personal
ready
bond,
for the
so
mail
you're
side.
going home.
Copy, Your Honor, please on the mail side.
Hello, what's your name, please?
Okay,
Okay, one moment. Okay, you have a couple of traffic misdemeanors where you missed your court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'm gonna set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors, which the maximum possible penalty is up to 93 days in jail and or a $500 fine, although it does not mean that's what would happen in your case. One moment, please. Okay, and Madam Clerk, if you would just make sure that there's not a nit for that civil infraction ticket. Thank you. All right. In ticket number P1445268, government alleges that on March 29th of 2023, in the area of Joseph Compound and East Verner, that you entered a vacant dwelling without the owner's permission. And in ticket U658211123, they allege March 29th of 2023 at an address on Joseph Campo. It looks like, again, an entering location without permission. On both of these, you do have personal bonds, and your next court date is going to be a pretrial in front of Judge Williams on January the 17th. Now calling case number 240-590-4001, people of the state of Michigan versus Christopher Jackson. Counsel.
Lisa Coyle, appearing on behalf of the people.
Jessica Shive on behalf of Mr. Jackson, who has formal reading, understands his constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, people see no criminal history, thus no capious history for Mr. Jackson. This is all caught on video. It's non-assaultive. There's, people are requesting a $15,000 personal bond, no contact with the Spotlight store.
Okay.
No objections, Your Honor.
Thank you. Mr. Jackson, do not go to the Spotlight store where this is alleged to have occurred. You cannot go there as a condition of your bond, which is set at $15,000 personal. Your next court date is going to be a probable cause conference, December 20th. After that, preliminary examination is set for December 27th. Both of those are set in front of Judge Giles. Thank you.
Thank you.
Right. Thank you. Thank you.
You want to go back 30?
Hi, what's your name, please?
Christopher Bohannon.
Okay, Mr. Bohannon, one moment. All All right, Mr. Bohannon, you've got some traffic misdemeanors where you missed court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'm gonna set the warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say can be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and/or a $500 fine. Ticket number P15011420 alleges September 15th of 2023 at Hubble and Midland, driving license never acquired. U20559506 alleging September 7th of 2006 in the area of address on Prevost disorderly conduct. P1123492 alleges October 16th of 2020 at Evergreen and Wadesworth that you never acquired a license, no insurance, and improper plates. P1134347 alleges November 12th of 2020 at Auburn and West Chicago, no license, improper plates. P1187821 alleging April 14th of 2021 at Lasher and Grove, license suspended, no insurance. P1193062 alleging May 13th of 2021 at Stansbury and Finkel, no insurance, license suspended. P1242182 September 13th of 2021 at Hubble and Wadsworth, driving while license suspended, repeat offender. P1309742 February 3rd of 2022, license not valid, no insurance. P1311221 February 8th of 2022 at northbound Vaughn and McNichols, no license. P1315649 February 16th of 2022, reckless driving, no driving while license suspended and no insurance. P1630597 October 6th of 2024 at Hubble and Joy, unregistered vehicle, improper plates, no valid license. U262-66806 alleging December 6th of 2006 at Schoolcraft in Archdale, illegally aiding or abetting a minor with violating curfew. It's like maybe those are your kids. Bohannon is the last name. 12646, maybe siblings. I don't know. I'm just noting the same last name. 12646-440, November 23rd, 2012 at Plymouth and Fielding, license not valid and no insurance. On all of these, you do have personal bonds and the same court date, same judge, January 15th in front of Judge Yancey. Now calling case number 240-615-601, People of the State of Michigan versus Christopher Bohannon. Appearances, please.
Thank you. Good morning, Steve Vincent.
I never had a license.
Hold on, sir. Jessica Sharp on behalf of Ms. Runa, who has full reading, understands his constitutional rights and stands mute.
Thank you, counsel. The court notes formal, did you waive formal reading? Sorry, stand your client mute?
Yes. Yes, sir.
Okay, thank you. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf, and I'll hear arguments as to bond.
Magistrate, we're asking for a $10,000 cash surety. We're also asking for a tether as well as a curfew. There's too much going on with this.
Fail to appear here. Okay. All right. I'm sorry, Mr. Vincent. Go ahead, please.
That's okay. We're going to be requesting a $10,000 cash surety. We're going to be asking for a tether as well as a curfew. There's too much going on with this defendant presently to not consider him a danger. We have the allegations here, which I'm sure Your Honor is familiar with. We have an individual, the defendant, who ends up punching somebody allegedly in the custody of the police, ends up threatening to shoot up a neighbor's house. That same neighbor was an individual who ended up making a report on this defendant 2 days prior to this incident for destruction of property. We have a defendant where I see it on September 4th of 2024 was sentenced to 2 years probation for an assaultive crime. I ended up sending magistrate judge yourself as well as defense counsel a copy of that investigator's report that the defendant was involved in. He had a multitude of charges. Ultimately, he ended up pleading to an MDOP of police property as well as an attempt R&O. The R&O had assaultive aspects to it regarding a police officer. And we have a warrant out of Farmington for disorderly persons obstructing the police. Putting the warrant aside, because quite honestly, it's academic in this matter. We have an individual on probation for an assaultive type crime. We have an individual in this particular case who allegedly assaults somebody, then threatens to come back to the individual's house or the neighbor's house to shoot it up. And this incident just took place December 9th.
Sir?
December 9th. So this was just 3 days ago. So for the safety of the complainant, for the safety of individuals involved in this matter, and as a direct result of this defendant having pled just 3 months ago and being put on probation, we do find him to be a danger. I know it's an A and B judge, but there's a lot going on with this defendant. There's a lot going on with this fact pattern. We find him to be a danger and respectfully asking for that cash with monitorization.
All right, thank you. Defense?
Your Honor, there are two sides to every story, and frankly, this is very concerning. I know that the people made their argument, but this is a 14-year-old child who her mother left the state. My client is her father, who she lives with and he takes care of. And according to my client, this complaining witness took his 14-year-old daughter. She's in his house, that she doesn't want to see his father. He's concerned that she's in trouble, and so are we, Your Honor. And it's very weird in the report that even the complaining witness says, oh, I'm very close with Miss Smith, who is his daughter. Unique Smith is my client's daughter. She's 14 years old. The fact that the complaining witness, who's 34, this isn't an elderly woman or elderly man, maybe a neighbor that looks out. This is a 34-year-old man that says he's very close, who has absolutely no relationship at all, family-wise or anything like that. And he has his 14-year-old daughter in his house. She's not seeing her father. And whether, one could make an argument, oh, maybe she's scared of her father. She doesn't stay with a 34-year-old stranger next door, and he wants to tell the police that we're very close. That's concerning. So yeah, my client told us this complaining took my daughter. She's 14, and there was another white guy there, and he doesn't know what's going on, and he feels that she's in trouble. She refuses to see him. And when the police arrive, they write in the report that there's an altercation originated from a custody dispute involving the daughter of the defendant. I don't know what kind of custody dispute could be between a stranger, a 34-year-old neighbor, and a 14-year-old daughter. This is very concerning. It's very weird. I hope that she is safe. And instead of the police, saving her or taking the right matters, and she's 14, she's not 18, she's not 19, she's not an adult. They arrest her father, and now he's in jail, and her mother's out of state. So it's very confusing, and it's very wrong. And no, he's not a danger. She's actually in danger. So I am respectfully asking the court to consider a personal bond. And again, the report that they brought up, in the past, I think that has to do with the same complainants. There's clearly issues. This is not a person who's related. So I'm respectfully asking the court to consider a personal bond, and I'm going to ask that he actually be allowed to go to his house because his daughter is next door.
Okay, thank you. Mr. Vincent, do you have any response to that? That is quite concerning.
I don't have a response to, what the defendant is coming up with in terms of the argument. I mean, in terms of the past, I think that's why I wanted to lay a foundation for this individual sending over the investigator's report from the previous case. I mean, we have an individual here, and I understand defense counsel is trying to posture the defendant the light most favorable, to their side. But we have an individual who ended up just pleading to the assaultive of assaulting a police officer, of trying to actually pull the door off of a police car to free one of, an individual that he was with. and then fleeing. I mean, this
Okay.
this
So
isn't an
let's-
individual
thank you.
who's, you know, who's all innocent and holier than thou. I mean, he's on probation for assault. Now we have an assault in front of us.
Okay, thank you. I asked you for the argument. So hold on. I appreciate the argument. As I look at the complaint, as I look at the investigator's report, okay, the complainant is in fact listed as a Bruce Connor, a 34-year-old man. So that is in line with what the defendant is telling us, that this is a Bruce Connor, a 34-year-old man who lives in the city. I'm not understanding how, you know, there's no indication of a relationship between them and this minor. One moment, please. And this is charged as a misdemeanor. I will tell you, with respect to the investigator's report that was released with respect to the other incident, it made me curious. And I decided to take a look at what was going on the date that incident occurred, right? And that interaction with police. Because it was a big reaction to police taking someone. Canton, Ohio had released a video of a police involved death of a citizen. Those officers now having been charged with homicide in that case, okay, having been indicted. And so, you know, because there was this big interaction with police in that other case, and I was curious as to what might have been going on that day, why people would have maybe reacted to a police encounter in that way. And so I'm really not prepared to hold that against Mr. Bohannon, because there were some things happening in national news in the United States about interactions with the police on that day that may have caused people to become fearful and react in a way that they reacted. So dealing with the case in front of me, I now have a misdemeanor assault and battery charge. I'm hearing an explanation from the defendant that someone unrelated to his minor daughter has custody of her and he is trying to get her back, and he seems to be irate about doing that in police presence. Okay. But it's still charged as a misdemeanor. And given the explanation that I'm given, I'm not finding him to be an overall danger to the community. Mr. Bohannon, with respect to, you know, these particular individuals, right? I could assess you to be a danger to them, especially if they still have custody, if they still have possession of your minor child. This is not a way that you can interact. You are going to have to use the court. Stop. I'm not asking you a question. You are going to have to try to use the court system for this, all right? Or you're going to find yourself back in here, because you cannot have any contact with these individuals as a condition of your bond, all right? Your bond is set at $25,000 personal. No contact with these complainants. No verbal contact, no written contact, no contact with third parties or social media. Any attempt at contact would be considered a violation of the conditions of your bond. What I will do, however, is I will make an exception for police contact contact with those parties through police, if you're trying to work these matters out, so that trying to do that does not violate your bond conditions, okay? Okay. All right. Next court date, December 23rd is the date for your pretrial in front of Judge Bryant. Thank you.
Thank you.
Okay.
Excuse me, how everyone doing today? My name is Giovanni Carson. I try to tell everybody my family life on mine. I'm walking on eggshells with the police.
Sir, anything you say right now, Kendon, will be used against you, okay? It's all part of the record. Please don't say anything at all for your own protection, okay? Just hold on.
Wait a minute, hold on, sir, because you started talking so fast, I didn't even hear your full name. What's your full name?
My name is Giovanni Amante Carson.
Okay, Mr. Carson, stop. Mr. Carson, stop. I promise to give you a chance to talk, and say anything you want to say when I finish my part, okay? Can we make that deal? Let me do my part, and then you'll talk to your lawyer, she'll advise you, and then if you still want to talk, it's your right to talk, and I promise to let you do that. The first matter is you got some traffic misdemeanors where you missed your court dates. And when you miss those court dates, the judge, hold on, please. The judge assigned to those cases issued warrants and they set bonds. I'm gonna set the warrants aside today, and I'm gonna give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets, and if you can't afford an attorney, one will be provided for you on or before your next court date.
Yes, ma'am.
These are misdemeanors, for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. It doesn't mean that's what would happen in your case. Ticket number P1513043 alleges November 2nd, 2023. Sir, please, listen to me. Listen to me, because I want to let you talk, but if you don't let me do my part first, I have to mute you, and then nobody's going to be able to hear you. So I've already promised you that I'm going to give you a chance, but you have to let me finish. All right? I know it's not easy. Okay, I will slow down for you. In ticket number P1513043, government alleges that on November 2nd of 2023 at Gratiot and Mount Elliott that you were engaged in disorderly conduct. In ticket number P1602095, government alleges August 2nd of 2024 at an address on East Hancock that you were trespassing. On both of these tickets, you have a personal bond. You have a pretrial date of January 16th in front of Judge Kennedy. Right now, we're going to go to your other count, which is case number 240-455-3301. People of the state of Michigan versus Giovanni Carson. Counsel.
Thank you, Magistrate Judge Stevenson for the people, P71917.
Jessica Scheib on behalf of Mr. Carson, who is formal reading, understands his constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Carson's behalf. He's charged with refusal to get fingerprinted. Has he been fingerprinted at this time?
Yes, ma'am.
Okay. All right.
Yes, ma'am. I've been fingerprinted. I got my tattoos. They got my tattoos. Everything you talking to me.
Okay, Mr. Carson. Okay, I just needed to know if you had been fingerprinted. Thank you, Mr. Vincent. Position is to bond.
Yeah, I think that was the issue here, Magistrate. I mean, it's the fact that he wasn't fingerprinted. I mean, the one question remains on that July 8th, 24, when he was arraigned. I think the order said must be fingerprinted before release. So, it probably should have happened then. I don't know how he ended up getting released, but it's a capious 1,010%. There are two failures to appear. The second failure to appear ended up leading to the capious. Now, I'm going to ask you to continue this, even though he's been fingerprinted. He failed to appear twice, and now he's on probation right now. He ended up pleading to an attempt R&O October 25th of 24. I mean, there's a lot going on with this individual. I don't know why he was refusing the fingerprinting. The people are always reserved when somebody refuses, trying to conceal or hide something. Our argument is that based on the two failures to appear, that we're going to ask you to continue this. This isn't 110% like Judge Bryant sometimes issued. This is 1,010%. So respectfully, Judge, we're asking you to continue this bond.
So he pled to an attempt R&O when?
October 25th of 24.
Okay, so that would mean subsequent to this capious judgment, then we've got him appearing for court. He's had to have been fingerprinted in that case because he's pled. And so we've got the fingerprint issue should be resolved at this point. We've got fingerprints on file. And he's appeared.
Yeah,
he didn't appear in this case, but he's been appearing in other cases. Okay, all right. Thank you. Defense counsel.
Respectfully, Your Honor, I'm gonna ask for a personal bond. This is, non-assaultive. Now he's been fingerprinted. He's a lifelong resident. I understand that the court's concern and the people's concern is about him coming back to court. We did get his brother's phone number. This case will be with our office, continue to be with our office. We have updated contact information. And so we will be in contact and making sure that he's at his court dates, Your Honor. So I'm asking the court to consider a personal bond and to mark his file medical, please.
Okay, DDC, please mark the file medical. Given the current posture of everything, I think a personal bond is appropriate here. We're gonna give a $10,000 personal bond. But Mr. Carson, you gotta come to court, because this is not the kind of thing somebody's gonna keep you locked up for in the end, but they'll keep locking you up if you don't show up for court. So just come to court so you can get this done and not be locked up and put in jail for stuff like this, okay? $10,000 personal bond. You don't have to pay any money to get out today. Hold on, you don't have to pay any money to get out. Your next court date's gonna be in front of Judge Bryant, December 23rd. Now, I promise to give you it.
Is this a new case?
It must be related to something, an old case, because it was just a refusal to get fingerprinted in the past, okay?
Understood.
Okay. So personal bond, December 23rd in front of Judge Bryant. Now, Attorney Scheib, do you want to advise Mr. Carson? Because I did promise him that he would have the opportunity to speak if he wished to do so.
Yes, thank you, Your Honor. So Mr. Carson, you got a personal bond. You don't have to pay anything to leave. You do have a right to speak. The court promised you Kentucky, you do have a right to speak, but as your attorney, I'd advise you to not say anything. You don't have to say anything at this time, but if you'd like to, that's your right.
Okay, anything else you wish for me to know, Mr. Carson, given that advice?
Yes, I love friends, and I ask for space, and I made it known to the world that I'm in space, and I don't want no friends. It's time I get my head right and become a grown man to feed my family. Cause I gotta live. I got shot 16 times, and I can't be playing with nobody. You feel me?
Yeah. So you're out on personal bond, so you can do whatever you need to do within the bounds of the law to take care of and feed your family, okay? You're gonna go on home today so that you can do that. All right, have a good day.
How you feeling, Judge? You feel better?
I'm getting there. I think I'm just left with a lingering sinus infection at this point, but I'll get through that. That's a regular occurrence. Thank you for asking. How are you doing?
Good, good. I mean, just status quo. When, magistrate, when do you take the bench as a judge?
Oh, sometime after the 1st of January, I believe. Thank you. Thank you. All right. Hi, what's your name, please?
Javon Randall.
Okay. Mr. Randall, security. All right, Mr. Randall, calling case number 24061005001. People of the state of Michigan versus Javon Randall. Counsel.
Please, the court appearing on behalf of the people. Justice Steib, on behalf of Mr. Randall, who waives formal reading, understands his constitutional rights, and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Arguments as to bond, please.
Your Honor, the people are asking for $150,000 cash surety, tether, house arrest on this, as it appears that Mr. Randall is a danger to the community as well as to the complainant, Mr. Guyton, 54 years old. He now, based on Mr. Randall's actions, suffered from a gunshot wound to the left side of his neck. It appears that they were all friends and that the defendant was not pointing the gun once, but pointing the gun twice. And then when Mr. Guyton turned back to watch video games, he had seen Mr. Randall pointing the gun for the second time, and then he felt pain and he realized that he was shot in the neck. Also, as basically an admission, the defendant came over to the complainant crying and apologizing for him shooting him, and then he left. He did in fact turn himself in to the 8th precinct, which is commendable. He admitted that he was high on Xanax and the shooting was an accident, and that he was so high that he didn't remember the details of the shooting. So what I see here is, unfortunately, a 18-year-old young man with no criminal history that has a .45 caliber handgun that they had seen prior to this, that he was pointing, per the complaint in the IR, that he was pointing the gun at not only him but others at other times. And there was an argument over a girl shortly before this shooting, Your Honor. So this is a question as to a trial issue as to what occurred, whether it's an accident or whether intentional. But what we're here to decide is as to the dangerousness to the community as well as the complainant. So based on the fact that he's 15 years old, that he's got a loaded weapon around several individuals, that he's high on Xanax, he doesn't recall in his words, the shooting, but that he's at this house and that they're playing video games, and then the argument ensues, and then he takes out the gun and then he shoots the complainant in the neck, which for the complainant is very lucky that he did not die as a result of being shot in the neck. So for those reasons, Your Honor, the people are asking for $150,000 cash surety, tether, house arrest. Thank you.
Thank you. I mean, I was looking at the investigator's report, and defense counsel, I'll give you your chance to make argument, of course, but what stood out to me is this is charged as an AWIM, and I was wondering why, given all the things that you just stated, Ms. Coyle. But what I do see in the investigator's report is it states that the complainant had threatened to shoot the victim, or the defendant had threatened to shoot the complainant over this girl some point earlier, at least according to the complainant. And so that's why we end up with an AWIM charge versus a reckless discharge causing injury or something like that. That is what's causing us to be dealing with AWIM at this point. All right, defense counsel.
Your Honor, Mr. Randall is 18 years old. He's not on probation or parole. He has no priors that we are aware of. He has no capious history. I know he's young, so I can't really talk about his history, but sometimes we see individuals who get in trouble at 16, 17, 14, and then it leads up to this. From my knowledge, this is the first time that he's in trouble. Ms. Coyle's shaking her head no, so maybe I'm wrong about that, but I will continue. He turned himself in, Your Honor. He turned himself in on very serious charges like this, which I think should speak very, very highly to the court. He's employed. He lives with his mother. His mother, who we spoke to, said that she was hiring an attorney. I have the attorney's name. I won't put it on the record. I did call the attorney right now. He said that he hasn't been paid yet, but he has talked to the family and he wanted more information after the arraignment because I believe he's planning on representing. So the family and Mr. Randall are taking the right steps. I don't believe he's going to be at flight risk. He already turned himself in. The mother, he has the family support, and his mother hired an attorney. Now, a couple things in the report, Your Honor. On the first page, the last sentence, it says that Mr. Geisen only stated that he got shot out front of the above residence and that he doesn't know who shot him. That's the last sentence in the first. And then I also see in the report that this individual, the complaining witness, was staying here because he ran away from his home. Now, I don't know why. I can't speak. I don't know if it was because he's in trouble and a troublemaker's got things going on, or his family, is not good. I can't speak for that, but it does lead me to believe that, this is an individual who ran away from his house, for whatever reason, and is staying somewhere else. And then allegedly, this happens. Now, I know that these are very serious charges, at least for count one. I know that the court has to make a decision here and weigh community safety, although he has, these are allegations and he's presumed innocent unless proven guilty beyond a reasonable doubt. I'm going to respectfully ask the court, whatever bond is considered, to consider a GPS tether and house arrest. He doesn't need to leave. He is employed 3 to 10 p.m. But if the court is going to say he can't leave because these are very serious allegations, we understand he'll be released to his mother's custody. And as stated, he turned himself in, and there's already an attorney that's supposed to be retained on this matter. So any bond at this time is unaffordable. If the court is not inclined to do a personal, given the allegations, I'd ask for at least a 10% bond with that GPS tether and house arrest.
Thank you. Can someone give me a pen, please? This one is not working anymore. Thank you. All right, there's a lot going on here. Thank you. There is the only, would-be witness, it seems, was in a different room with the door closed at the time shots were fired. I can't really tell how many people were in the room at the time. I've got a complainant at one point saying he was shot outside and didn't know who shot him, and then saying he was inside and he's confident shots came from inside the room. So there's a lot going on here in terms of even the complainant's ability to say what happened and this defendant's ability to say what happens. Doesn't seem like anybody really is very sure. What we do know is that someone got shot in the neck, and we've got the defendant who says, hey, I did it, although I wonder how sure he even is of that, given what his state was at the time. Ms. Coyle, was there something additional that you thought I should know about defendant's prior convictions?
No, and the reason I didn't mention it, because he has something at juvenile, which was an assault and battery, recent. I want to look at it. I'm going to pull it back up. That he went through, and the reason it says it was dismissed in July, but it looks like it was over a year old, so he might have been on some sort of diversion, or it doesn't say juvenile adjudication. So that's why I did not bring it to the court's attention, because unless I know that there's been a conviction, I don't want to say, but he has been, this came out of Redford. He was petitioned out of Redford, and then it went through juvenile. So that it's not a felony. If anything, it's a misdemeanor, but it is assaulted.
Right. Thank you. Given the circumstances in this case, I do think some level of cash bond is appropriate given dangerousness to the community. I'm not assessing Mr. Randall to be a flight risk, given the fact that he turned himself in. So I am imposing cash bond in a lower amount than I normally would. In this case, I'm going to impose bond at $50,000 cash surety. If he's able to make that bond, GPS tether with full home confinement at his mother's house, must reside with his mom on house arrest. May not purchase or possess any firearms or other dangerous weapons during the course of the bond, and no purchasing or possession of illegal substances during the course of the bond. That includes prescription drugs for which you do not personally have a prescription, Mr. Randall. Next court dates: December 20th for probable cause conference, December 27th for preliminary examination, both in front of Judge Giles. No contact or attempted contact with the complainant. And so, that could prove problematic if complainant is still residing at your mother's house. So, because you can't have any contact with that person, and I'm putting you on tether to your mom's house. So she's going to have to make sure that you have a place to go at her house without complainant being there. All right. Thank you.
Your Honor, may we have a redetermination hearing date? Sorry.
Oh, yes, I'm sorry. Redetermination to take place Monday in front of McConaughey. That will be the 16th of December. Thank you.
Thank you.
Hi, what's your name, please?
Marcel Chester.
Hey, Mr. Chestra. got a few traffic misdemeanors where you missed your court dates. Looks like just one, actually. When you missed your court date, the judge assigned that case, issued a warrant and set a bond. I'll set the warrant aside today and give you personal bond on the ticket. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the ticket. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and/or a $500 fine. To get P1569490 alleging April 1st of 2024 at Connor and Mack driving while license suspended. On this ticket, you have a pretrial date in front of Judge Kennedy, January 16th, and it is a personal bond. Now calling case number 240-608-3101. People of the state of Michigan versus Marcel Chestra. Counsel.
Steve Vincent for the people.
Jessica Scheib on behalf of Mr. Chestra, who is formal reading and extends his constitutional rights and stands again.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Magistrate, the defendant has 3 ongoing cases right now over in circuit court. This now being the 4th. They all have similar charges, and they all have $50,000 personal bonds with Tether. 2 of the cases have offense dates before this offense date. And then there's one case that has an offense date post this. And if we just impose the same bond that the other cases have, it's a $50,000 personal, and all of the charges are very similar. I have one with a felony larceny, felony false pretenses, ID theft. I have another with a felony larceny, ID theft, and an ID theft second offense. And then the third case has a felony larceny with an ID theft. I believe ID theft is the issue in this particular case. So respectfully, we'd just be asking for a bond consistent with those other cases.
Okay, thank you.
No objections to a personal bond. He was picked up at home for this warrant, not because of anything else. This allegedly is from over a year ago, and it was not signed until a year after. He has 2 kids, lifelong resident of Michigan, understands he needs to make it to his court date, so we're not going to be objecting to that bond, Your Honor.
Thank you. Just to be clear, request from the people is 50,000 personal, is that correct?
50,000 personal with the monitorization consistent with all the other cases. Yes, Magistrate.
What were the conditions of the monitorization in the other case?
That I couldn't tell you. I have a case with an offense date of February 25th of 23, given the 50,000 personal with a tether. And then I have a case October 31st of 23, which is about 3 weeks prior to this incident date, same bond. But unfortunately, Magistrate, I don't know the conditions, because what I pulled out was from Odyssey, and the procedural history.
All right, thank you. Attorney Scheib, you want to voir dire your client just as to whether he's on tether currently and what the restrictions on that tether are, so that I can impose similarly?
Yes, ma'am, I'm on tether.
One sec, sir. What, sir? One sec.
You're to direct the specific questions that she wants you to answer, so you don't say too much, okay? One moment.
Okay.
All right, sir. Anything you say right now, Kenan, will be used against you. There's prosecutors on, so just answer what I'm asking for your own protection, okay? Now, just yes or no. Are you currently on a GPS tether?
Yes.
And is that house arrest?
Yes.
Okay, thank you.
Thank you. All right. Bond is set at $50,000 personal. Before leaving the jail, if not already fitted, must be fitted with a GPS tether. That GPS tether requiring full home confinement. Right. Next court date. Okay, well, you don't have to get another tether. That's okay. You'll just keep it on. Okay, it's not 2 tethers. All right, next court date, December 20th for probable cause conference, December 27th for preliminary examination. Both of those in front of Judge Giles. Thank you. Hi, what's your name, please?
Shamar Mathis.
All right, Mr. Mathis. Calling case number 240-593-8701, people of the state of Michigan versus Shamar Mathis, counsel.
Magistrate, it appears as though that this is a felony capias. I have 3 failures to appear. I have the most recent capias, December 4th of 24. Because it's a felony capias, the city isn't going to be appearing.
Thank you.
So, Your Honor, I know this court doesn't have authority to change the bond. We did file an emergency motion. At this time, we did not get an answer. For the record, I will say, just for Mr. Mathis's record, that he indicates he was sitting on Zoom that day, that his attorney told him that she had another case and that didn't come back to him, and then or rescheduled his case. I'm not sure what happened there, but I know this court doesn't have authority to change the bond, or I would have asked for a personal bond. He originally had a personal bond, and the capias on December 4th was a review date. So respectfully just ask the court to keep the file nearby if we do get an answer.
All right, I'll keep it nearby, but at this time, given the 3 failures to appear that I'm hearing about, I'm going to go ahead and impose the bond at $2,000, 10% due to flight risk, as imposed by Judge Robbins. If we get something different before the end of the day, we'll recall it.
And
bond is set.
I'm sorry, go ahead, Your Honor.
Bond is set at $2,000, 10%. Next court date, December 20th for probable cause conference, December 27th for preliminary examination. Both of those in front of Judge Robbins. Mr. Mathis, you're not to purchase or possess any firearms or other dangerous weapons during the course of the bond.
And Your Honor, I'm sorry, I just, 1 second, Mr. Mathis, don't step away. I just wanted to ask the Mr. Vincent if the capias he was talking about was on this matter or another matter, because I didn't see any other capias on this matter.
I can just give you the procedural history, not making an appearance because this isn't something that what's in the scope of the city's now advocacy, but I have a 9/24/24 failure to appear at review, 1,010% by Judge Robbins. There was a bench warrant arraignment October 23rd of 24, given a $5,000 personal. October 30th of 24, failure to appear again a week later, 1,010% issued by Judge Robbins. Bench warrant arraignment about a month later, November 25th of 24. At that particular arraignment, it was continued. So he was supposed to appear for a redetermination, but he ended up posting prior to redetermination the $100, and then about a week and a half later fails to appear, hence given the 2,010% by Judge Robin, upping the stakes from the 1,010% previous to capias.
Okay, thank you for that.
But it's not my case, so I just wanted to put it on.
I understand. Thank you.
Bond is imposed at $2,000, 10%. Bond review hearing will take place on Monday. That is December the 16th. It's still in custody in front of McConaughey. And then those other 2 court dates will remain in place on the 20th and 27th. And as I said, if we get a different decision as to the bond prior to the end of the day, we'll recall the case. Thank you.
Thank you.
Hi, what's your name?
My name is AG.
Okay. Calling case number 220-440-0301. People of the state of Michigan versus Ronell AG. Counsel.
Mr. Foyle appearing on behalf of the people.
Jeff Shab on behalf of AG, who has formal reading, understands his constitutional rights, and stands mute.
Thank you, counsel. The court notes formal reading has been waived in interest of not guilty plea on your client's behalf. Misdemeanor AV is the charge here. Positions as to bond, please. Looks like there's capias.
There's 2 that I see, Your Honor, and the last one being October 22nd, which he received a $500 cash bond with a tether. But obviously he didn't get a tether because he wouldn't be on capias status if he did. So I'm asking for that bond to be put in place with that tether. Obviously it needs one.
I got
Yeah, I'm not sure he's been arraigned on that capias, actually. Okay, I'm looking.
He was arraigned on the first one. Oh, I'm sorry. His first failure to appear was a $500 cash surety, and he posted bond back in March. And then it looks like in March later, he was arraigned as well. And then he had a failure to appear. So today is my understanding from the ROA is his.
They were arraigning on the KPS, the $500 cash with tether. Okay, gotcha. Thank you. Ms. Shive.
So Your Honor, according to my client, he has a tether already. And I'm gonna ask him if the court was in mind to clarify.
Go ahead,
May I?
please. Yes.
Okay, so
Go
sir,
ahead,
anything you say right now, can and will be used against you, okay? So don't say anything other than what I'm asking, just yes or no, not further information, that's for your own protection. Are you currently on a GPS tether?
Yes.
Okay. Thank you. Your Honor, this is a misdemeanor allegedly from 2021, entered 2022. He missed court in 2022. He said his paper didn't say when his next court date is. I understand that people argue there are multiple cases. This is an older matter. It's unfortunate that he is in custody, for the missing court. And this is a misdemeanor that could have been resolved. He understands that. We have updated contact information. It's my understanding, again, he's already on a tether. He is employed 10 p.m. to 6 a.m. I'm respectfully asking the court to consider a personal bond.
All right, thank you. I'm sorry, the conditions of his tether currently?
Sir, are you currently on house arrest or with a curfew or work only?
I'm just on tether, so I'm not on curfew, anything.
Okay, thank you.
All right, thank you. All right, here's what we'll do. Honestly, 2022 to then, I don't know what happened between 2022 and then getting a court date in 2024. It's a long, no, you can't, not yet. You will be able to, but not yet, okay? That's a long time for a person to try to remember court dates. And so I'm not really gonna hold that against him so much. So I'm gonna do a personal bond here at $10,000 personal, but I will require a GPS tether in this case as well. I won't put any restrictions on the tether because it's really just to ensure that he's getting to court. $10,000 personal, GPS tether, same one you already have on, no restrictions on it, okay? Just got to get to your next court date. Now, the judge has indicated that you must appear in person for this court date, not by Zoom, understand? Right, so that's going to be December the 20th for pretrial in front of Judge Garrett. The no contact with the complainant remains in place. All right, Ms. Shai, do you want to advise your client, and then if he wishes to speak, he may do so.
Yes, thank you. So, sir, again, anything you say right now can and will be used against you, all part of the record. You got a personal bond, which means nobody has to post any money for you to get out. You did get a tether already, like the one you have. At this time, if you want to say anything, you can, but as your attorney, I'd advise you not to. But you've got a personal bond, but if you do have a right to speak, so.
That's it. Thank you.
You don't have to say anything, sir, but it is your hearing, and if you wish to do so, you may. Right now, it's gotten as good as it can get for you, I think. Got a personal bond, no changes to the tether that's already on you, okay? You just have to keep it on with this case as well. Anything you wish me to know?
No.
Or wish to ask? Okay, all right, have a good day.
Thank you.
Your Honor, may I have the court date one more time, and Judge?
Yes, court date is December 20th, Judge Garrett.
Thank you.
Thank you. Hi, what's your name, please?
Hi, I'm Jamal Clark.
All right, Mr. Clark, you've got a couple of traffic misdemeanors where you missed court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. They are misdemeanors, which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Ticket P1489022 alleges September 4th of 2023 at West Grand and Lawton, disobeying lawful order of a police officer and possession of drug paraphernalia. X1456313 alleges March 7th of 2015 at an address, the ramp on West Grand Boulevard and I-94, no operator's license having been cited for that before, and U638-13522 alleging May 31st of 2022 in an area of see. Boy. Address on Mack Avenue, possession of drug paraphernalia. On all of these, you do have personal bonds, and your next court date is going to be in front of Judge Kennedy for pretrial on January the 16th. Now calling case number 220-608-8301, people of the state of Michigan versus Jamal Clark. Counsel.
Lisa Coyle appearing on behalf of the people.
Jessica Shab on behalf of Mr. Clark, who has formal reading, understands constitutional rights and stands mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf, noting there is already a $1,000 personal bond capias in the case from Judge Sabri. That's what the court will impose. Is there anything anyone wishes to put on the record?
No, Your Honor.
Nothing further. Thank you.
All right, thank you. Bond is imposed at $1,000 personal. Next court date, December 20th for probable cause conference, December 27th for preliminary examination, both of them in front of Judge Sabri. Thank you. Good morning. What's your name? Okay, Mr. New. Good morning to you. All right, Mr. New has a number of files in front of me. Any objection to these being called together?
No, Your Honor. Thank you.
Thank you. All right.
Good.
Get these all laid out. Okay. All right, let's get started. All right, I've got case number 240-04-616-001, People versus Richard New, stalking. Case 240-461-6101, People versus Richard New, stalking. Case number 240-461-6201, People versus Richard New, stalking. Case number 240-461-5901, People versus Richard New, assault and battery. Case number 240-461-6401, People versus Richard New, stalking. Case number 240-461-6201, People versus Richard New, stalking. Counsel.
Lisa Coyle appearing on behalf of the people, Your Honor.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Richard New, who stands mute, waives the reading of the information, asks for the plea of not guilty in attorney's behalf. Mr. New has been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. Arguments as to bond.
Your Honor, I don't even know where to start, but I just, to put some context into this as I read through it, apparently this is the same complainant. They are neighbors, Mr. Graves and the defendant. Mr. New is 89 years old. This has been going on since, as we can see, at least from 2022. Now, all these warrants were signed when they came in, these older warrants. I note when he picked up the December 9th case, in which the facts that he allegedly came out with the cordless drill or the gun, and basically pulls it out and he struck the complainant's car. Then the prosecutor's office issued the other warrants that have been sitting there on the 11th, and now they're all here in front of this court. I do note, I'm not sure if at this point he's still on probation. This is, I believe, a different victim on the assault and battery, another neighbor in 36th District Court. He was just sentenced in May of this year. But he was just arraigned on the other day in front of Magistrate Koplarek and given a $35,000 personal bond in this matter on another assault and battery. I also note in circuit court, he had a felonious assault. It was dismissed on October 29th of 24. And reading the notes, it was dismissed by the people in the best interest of justice. There is, I believe, some mental issues going on here as well. So for that matter, Your Honor, of course, we're asking for the condition of no contact with the complainant. He must also, the defendant must stay on his own property, and for no reason have any contact with Mr. Graves. The people have no objection to a high personal bond in these matters, Your Honor, with those specific conditions that there's no contact with the complainants, the neighbors, or their property. Thank you.
All right, thank you. All right.
So Ms.
Ms.
Coyle
Stevenson.
has let the wind out of my sails by asking for personal bond. We'd ask the court to follow that recommendation, Your Honor. I am very, very, very familiar with Mr. New and with Mr. Graves. The two of them just do not get along at all. We already have been in trial. We had 2 trials on one day. One of them, Mr. New got found guilty. That's what he's on probation to Judge Holmes for in the specialty court because he is a Korean War veteran, not because has mental health issues. He just celebrated his 89th birthday this last Saturday, Your Honor. We were in Judge Holmes' courtroom and had cake for him and everything. But I don't know what it is with Mr. Graves, but he does not like Mr. New at all. One of those trials, Mr. New got found not guilty on. And I also, just for the record, I don't know how you do stalking on one time. So we have serious issues with regard to the people's ability to prove these cases. And that's one of the factors that the court knows it has to take into consideration when setting bond. I'm asking the court to let Mr. go on home and give him the personal bond the people have recommended.
All right, all right.
Just say
Yes.
this. I would never say that there was mental illness if I did not have some information. And so there was notes in the file that from his case in circuit court as to him receiving counseling and such. So that I just want to put on the record that I'm not asserting anything that is on conjecture. Okay, thank you.
All right, well, who knows? I mean, hopefully we're all blessed to see the rightful age of 89. Mr. New, I'm gonna give you personal bond so you can get on home, but you got to stop interacting with Mr. Graves under these bond conditions, okay? There wasn't, the last allegation was that he banged the car with a cordless drill. I didn't see anything about a gun there. I'm not, concerned about that. But, sir, this is not how you want to be spending your time. 50,000 personal, no contact or interacting with Mr. Graves, okay? No contact. I understand you sounds like you guys have been feuding over property lines for a while. Just stay away from him, okay? Stay away. Next court date, you're gonna get these all done at the same time. January 2nd for your pretrial, you're gonna be in front of Judge Bryant, okay?
Good, Mr.
right.
New. Did you hear what the judge said about your court date?
No,
January 2nd.
he gonna give it to me.
Okay. Okay.
Personal bond, January 2nd, all right? Belated happy birthday to you. Stay away from Mr. Graves.
I stand away from him.
All right.
He
Okay,
always
it should be all good.
He make good threats with me all the time. And I just tell him
I get it. Sounds like you guys y'all don't like each other, so just stay away from each other. Okay. All right. Have a good day, sir. All right, everybody. Have a good lunch. I'll see you after.
Everyone is
Thank
welcome.
you.
Bye.